Well, I mean, it's not an apology to me. It's your father needs that medication for his pain and you're taking it. Do you know how deep that means you are into your addiction? Yeah, I mean, if you take somebody's medication and you don't tell them and it's for their pain, you are deep in the throes of your
It
addiction.
was with an older prescription of his.
That's an excuse.
No, I
That's not your
know.
meds. It's his. Parties announced for the record, state. Defense.
Stephen Harkowitz for Mr. Brown.
All right, and probation, this is an application. Did you review the discovery with your client and have you received all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And are you Mr. Brown?
Yes, ma'am.
Did you review the application for deferred adjudication with your attorney?
Yes, ma'am, I did.
Did you understand it and sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony.
Yes, ma'am.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be
Yes.
the plea? Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did
Yes.
you understand it and sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The
Yes.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence.
No objections.
State you may be excused. Did you review the waiver with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial?
Yes, ma'am.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the recommendation. Mr. Brown lives in Natalia with his fiancee. They have 1 child. They have another child on the way. He tells me that he is working and he's working really hard. So he's understands he's going to have to juggle his employment and comply with his court. And And certainly is
Where's Natalia?
a little south of,
South.
Medina County Judge.
All right, so are you all able to still supervise or no?
Yes, Judge.
All
well,
right,
he tells me he lives in Bear County,
Yeah,
he's right on the, like.
It's right on the edge of Bear County and Medina County.
all right. So let me ask you this. If you're drug tested today, what are the results going to be?
It should be negative with methamphetamine, but I did take some pain medication for my back.
Is it prescribed to you?
No, man, it's not.
You're not supposed to do that.
I know. I'm
And that's
sorry.
not good because you obviously have drug issues. All right. And here's the thing. I need you to be honest with me. And let me just tell you why. If you use drugs today, you are not on probation, so it's not a violation. I'm trying to figure out what are the best conditions for you so that you can be successful. So let's not start off by being untruthful with me, okay?
Yes, ma'am. I understand.
So guess what? Wherever we are now, we're all trying to improve in our life. I'm trying to be a better person. Everybody in here is. So where you start out is just hopefully this is not where we'll end up, okay?
No, it won't.
So- So if you're drug tested today, what are the results going to be? What are you going to be positive for?
Pain medication, I don't know, this is amphetamine.
Sorry, what?
A pain medication, amphetamine, I guess it is,
Mhm.
hydrocodone.
And whose medication is that?
It was my dad's.
All right. And you say it was your dad. Is your dad currently alive?
Yes, ma'am.
All right. So that's his pain medication
ma'am.
and you took it. Does he know you took his medication? No. So that's an issue.
Sorry.
Well, I mean, it's not an apology to me. It's your father needs that medication for his pain and you're taking it. Do you know how deep that means you are into your addiction? Yeah, I mean, if you take somebody's medication and you don't tell them and it's for their pain, you are deep in the throes of your
It
addiction.
was with an older prescription of his.
That's an excuse.
No, I
That's not
know.
your meds. It's his. Now, does your fiance work?
Yes,
What are her hours?
she works from home, so she's at home, she works from like 8 to 5.
And is she using?
No, ma'am. We just moved in together, like,
How long have you known her?
2 years, 3 years. now.
And she knows about your drug issues?
Yes, ma'am, she knows what I was.
Well, I mean, no, you're clearly still in the throes of your addiction.
Yes.
It's
I
not,
understand.
it's current.
Yes, ma'am. I understand.
All right, the court is going to sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, $1,000 fine to be probated. Proof of employment within 30 days, no employment as a home healthcare provider or with minors. There's to be no unsupervised contact with minors. There's to be field visits 1 time per month until further notice. I'm going to want a TAP evaluation out of custody. Follow all TAP recommendations. There's to be 120 hours of community service restitution. There's to be 120 sober meetings in 120 days. I'm going to order parenting classes. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No,
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. In this court, we can go off the record. In this court, to be successful on probation, communication is key. And the next time you come before me, you need to bring more than tears of disappointment. You need to do some action.
Yes,
And
ma'am.
part of that action is accepting responsibility and not making excuses.
Yes, ma'am.
The fact that you made an excuse that, oh, the medication is expired, that means nothing. You took medication that did not belong to you and your father needs it for his pain. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you. And this is.
In today's courtroom, the state charged Mr. Brown with felony drug possession. He asked the judge for leniency, claiming he wanted to change, but then admitted he took his father's prescription pain medication without permission. That confession changed everything. The judge made it clear addiction is not an excuse, but honesty matters. Instead of prison, she granted strict probation with drug treatment, community service, and constant monitoring. This was his final warning. One more mistake, and prison is guaranteed. So what do you think? Rehabilitation or jail? Like, share, and follow for real courtroom stories.
11 scene for Mr. Parra.
Are you Mr. Parra? Counsel, have you received all of the discovery? Did you review it with your client?
Yes.
Mr. Parra, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Your Honor, waive the repeater allegation.
Any objection?
No.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense? I'm sorry, did you hand me that back?
Yeah, I think you need that.
I don't have a copy.
Oh, I gave it to him already. You want me to?
Yes,
Okay.
that's okay. So let
Sorry.
me sign that one.
All right. Thank you.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Sure.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Parra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, sentencing is to be set at 8 months in the state jail facility. There's $1,000 fine and no applications. Did you understand that to be the plea? Defense is at the plea.
It is.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offer State's Exhibit 1 with attachments.
No objection.
All right, state you may be excused. Did you review the waiver with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Just, I'd like you to follow the plea bargain agreement.
All right, the court will find you guilty. The court will sentence you to 8 months in the state jail facility, give you credit for any time served. There's $1,000 fine. Time and money is to run concurrent. There's to be no contact with Walter Jordan Paddleford, Padelford. I'll recommend the therapeutic community. It doesn't increase the time that you're in custody. but it'll help you perhaps if you have drug issues. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal the only items, I'm sorry. Did you review, it's long. Did you review the trial court certification? All right, with your attorney, and you understood it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Let me ask you a question. What was the most painful tattoo? All of them? Yeah. None of them were painful? Not even the ones around the eye? Okay. All right. Well, good luck to you. Have a great day.
I just wanted to add one more thing. He's got, the clerk has told me he's got 122 days.
Okay. They'll make sure the credit is there.
And
All right,
thanks
good.
for squeezing us in.
All right. Court has reviewed the documents. Defense, do you have any witnesses?
Judge, he has three, his mom is here, Miss Gutierrez, his father is here, Mr. Gutierrez, and the girlfriend that's mentioned in the letter is also present. I can proffer what they would say.
All right. Any objections to the defense making proffers as opposed to calling the witnesses? All right. And where are the witnesses in the courtroom?
Mr. Gutierrez, would you stand up, please? And Miss Gutierrez? And Miss Salcedo?
All right.
that's it.
Thank you. You may be seated. All right. Counsel, you may proceed.
Judge, first of all, you could see he's supported here by his family. His father, Mr. Gutierrez, is a retired police officer. He served 30, looking at my notes here, he served 32 years as a police officer in New Orleans. He's married to Mr. Gutierrez's mother. They're very law-abiding people here in the community. They don't condone the substance abuse history that you see that Mr. Gutierrez has. They're very supportive of his application for community supervision in the community. And they would testify that they would like the court to grant his application for community supervision. They believe he understands his responsibilities in the community and to his family, and that he would make a good candidate for community supervision.
Oh, I'm so sorry. Could you speak up? Probation can't hear.
Excuse me. And his present girlfriend, who is the person would testify that the firearm belonged to her. It ended up in a backpack. She did not know, because the relationship had just started, that he was not permitted to have a firearm. It was in a backpack where his clothes were located. He took the backpack because his clothes were there. Didn't realize the firearm was in there, although that's very reckless. And the offense actually includes a reckless component. Mr. Gutierrez has accepted responsibility for his reckless behavior and not checking that backpack and knowing what was in there. So she would confirm what you read in his statement about the fact that the backpack belonged to her. He was stopped carrying the backpack on a bicycle. He was on a sidewalk instead of the roadway when he was stopped by the police. So that was the probable cause to stop. And there was a warrant for his arrest. He's been on parole for a long time, since he was released from a substance abuse conviction back in 2019. He served well in parole and never turned any dirty UAs into parole. There were some technical violations where, while he was in parole, he did serve a term in the state ISF for substance abuse. And while he was incarcerated, Judge, he also was in the therapeutic community there. So the TAP evaluation says that he's not motivated for treatment, but I have talked to him about this, and he would willingly accept any programs or counseling that the court believes is appropriate as a probation condition. He just feels like that he has had counseling, and he presently doesn't have a drug problem, although he will acknowledge the influence that illegal substances have had on his life. He just wants the court to know he hasn't used any controlled substances since his release on parole. He was employed while he was on parole. He's working for Ashley Furniture. The only reason he lost that is because when he went into the ISF program, he obviously couldn't hold that employment. So he's employable. His girlfriend, Miss Salcedo, would tell the court that she is interested in a long-term relationship with him. She will not have any weapons anywhere near him. She knows now that that's prohibited for him to have any kind of firearms or illegal weapons. And she's offered him a place to reside. She'll let him stay with her, and she wants to continue the relationship. He'd like to be a good citizen in the community. He'd like to comply with any conditions whatsoever, any conditions that the court wants to impose. His parole term has already really expired, and he understands that it is up to parole whether to reinstate it or not. But I think parole would take into consideration if the court were to grant a community service application. He is respectfully and humbly asking the court to grant his community service application. And based on my communications with him, I think you have a sincere defendant here begging for your consideration of his application for probation.
All right. Any witnesses?
Other than the proffer of the 3 witnesses, that's all I have, Judge.
All right. All right, State, you are opposed?
Yes, we are.
All right, I'll hear your argument, State.
States, first of all, individuals have previously convicted felonies, including by felons. But I believe he was CIC, that he did serve prison time. And then he also has a drug case that he also served prison time. And for those reasons, Judge, the state is opposed to the collision. And the last 10 years, that's part of it.
All right, defense court will hear your argument.
Judge, I would, if he wanted to address the court, I would call him as a witness.
All right, do you wish to address the court?
Yes, ma'am.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Island Michael Gutierrez.
All right, do you want to do this question or answer, or is there something you wish to say?
Did you just want to address the court about, in terms of an allocution about why you believe you would be a good candidate for community supervision?
Yes, ma'am. Ma'am, I have a brief statement. May I be able to pull out and read it to you, please?
Sure. But I will tell you this, the state will have an opportunity to question you if they choose to question you.
Yes, ma'am.
All right. And state, you have no objection to him reading a statement?
No.
All right, you may proceed.
Honorable Judge Boyer, thank you for considering my application for probation. I wrote this to briefly explain my desires within my heart and my life. My support system is in court today. My father, a Vietnam veteran, a 30 retired officer in New Orleans, a great loving mother, and a beautiful girlfriend who I will be residing with, who will take me to every appointment, community service, and etc. if granted community supervision. My girlfriend, Alana Salcedo, and I will be investing in a truck for a moving company for appliances and reassembling and disassembling furniture locally throughout San Antonio. May 26, 2024 was my 5th anniversary of sobriety. From 2020 to 2023, I had a stable job, a car, and a home. Please give me an opportunity to show you and myself that I am a perfect candidate for probation, freedom, instead of falling into another statistic and becoming just a number lost in the penitentiary. And if you feel to not grant me probation, Ms. Boyd, please have mercy on me and give me a number my family and I can handle so I can continue my rehabilitation from imprisonment and addiction, and once again be a productive member of society. Thank you for hearing my part of my testimony. God bless you, Judge Boyd.
All right, thank you. All right, State, any questions?
Yes, but did you get to prison in 2016 for unlawful possession of a firearm?
Yes, sir.
And then you also went to prison for a separate drug charge, is that correct?
Yes, sir.
And if you, yeah,
I'm not being good.
no further questions.
All right, anything else?
That's all I have, Judge.
All right, State, you're asking for 10 years? All right, Mr. Gutierrez, I want you to know that I listened to everything that you said. I listened to the proffer by your attorney, and it's no doubt in my mind that the witnesses who are here for support for you would have said great things about you. But with that being said, after listening to everything and reviewing the documents that were presented before me, I don't think you'll be a good candidate for probation. So I'm going to find you guilty. The state is asking for 10 years. Defense, what are you requesting?
Judge, he has about 4 months of credit. He's been incarcerated since the arrest. We had asked the court to consider the lower end of the term. You've heard his allocution to the court. He's asking for a sentence that would be something that would permit him to be released sooner rather than later. So we'd ask the court for the lower end of the range, please.
All right, the court is going to sentence you to a $2,000 fine, time and money to run concurrent. Court will give you credit for any time served. The court will recommend the therapeutic community. The court will sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I understand that you wanted, probation, but I have to balance certain things, look at everything that is presented to me. When you're released, if you have trouble finding a place that can help you, if I'm still here, you can come back to the court. All right, court is calling 2020 CR 12349, State versus Lindsay Phillips. Can I have parties announced for the record for the state? All right.
Eddie Brovnik for Ms. Phillips.
Oh, go continue. You can continue to confirm. Raymond or Ashley? Can y'all?
Yes. Please be somebody stand in.
Yes.
Michael Miller, off the stand.
All right, counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Phillips, did you review the application for community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Is this documents that tell you what your rights are? All right, you're charged with arson with intent to damage a habitation or place of worship. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason I do not follow your plea and give you more than what you've bargained for, the fact that you entered a plea will not be used against you. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand because you're entering into this plea bargain agreement, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights to enter into this plea bargain agreement?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, but I must put on the record, she was found incompetent at one point because she was off her meds. I thoroughly went over the sanity issue with her. There was a defense there, but it was not to the point that I thought she was insane. And so I'm just simply putting this on the record. Someone looked in the past and said she was found incompetent. And I had not put it on the record that I thoroughly examined it. I would worry about someone grading my report card. So I wanted to add more to that I thoroughly went over it, and I'm sorry to disrupt the court.
No, there's no disruption.
Oh.
Right. Ms. Phillips, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? It tells you what your agreement is with the state.
So the page she's talking about is the 10 years of probation that I showed you. She's asking if you looked over that. with me.
Yes, ma'am.
All right, so what it says is your punishment is to be assessed at 10 years of the prison. The state is offering you probation, so the only way you could potentially go to prison for 10 years is if you were to violate the probation. You understand?
Yes, ma'am.
And they're asking that there be restitution to SRMZ, the number 4 Asset Company 2 LLC, or property owner of 8042 Chestnut Gate in Converse, Texas 78109. Did you understand that to be the plea? Is that your plea agreement?
What she's asking you is if you've agreed to the 10 years of probation and if you've agreed to make restitution for the fine.
Yes, ma'am.
Is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? It's this paragraph here. Did you review that and sign that?
Yes, ma'am.
All right, by signing that, you're giving up your right to appeal or complain about something that has happened. Did you understand that?
Yes, ma'am.
All right. And the only thing that you can complain about or appeal on is if there were pretrial motions. Defense, have there been any pretrial motions?
Only the motion for competency, no dispositive motions.
Yes.
Just wondering, when do you think I'll be able to get out of jail?
All right, we'll get to that point.
I'm sorry. Yes, ma'am.
No problem. All right, so the state is asking that your probation be for a term of 10 years, that you have a TAP evaluation, community service hours, that you be placed on GPS, which monitors or shows people where you are, and that you have no contact with the location. Did you understand?
Yes, ma'am.
All right, I don't have to follow that. That's just what the state is recommending. Do you understand?
Yes, ma'am.
All right, so how do you plead to this case?
Bitch, I'm so sorry. I can't remember if I put no contest or guilty. I just can't remember.
You didn't write it in here at all.
You want to put guilty or no contest?
No contest?
All right, so how do you plead?
No contest?
State any evidence?
Yes, Your Honor. At this time, state offer states exhibit number 1 is attachments.
No objections.
All right, state, you may be excused.
You.
Did you review the waiver? It's this piece of paper here. And what this piece of paper has in it is all the police reports and everything that I need to review to see if there's evidence beyond a reasonable doubt that you committed this crime. Did you review this with your attorney?
Did you look over those documents?
Yes, ma'am.
All right. Now, did you understand that the state is not going to bring any witnesses? They just want me to read this document. Did you understand that?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Salazar?
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
So Judge, I know she wants to get out today. Here's the deal. I've heard you ask many times, what do you need to be successful? I know Ms. Phillips in her case very well after 4 years. She does have mental competency issue and she needs to be on medication. My concern is if you let her out today, that we make sure that she be evaluated so that she can be successful.
Oh, no, she will be.
Oh, okay. So in other words, yes, I want her to get out and she wants to get out, but I don't want to set her up for failure because you always ask people, what do you need to be successful? And I actually listen to you. And
Yes.
she needs to be evaluated and needs to be ordered to follow through with the medications and the treatments. When she's treated and when she's medicated, she's a very nice young woman that follows the law. When she's not, she has issues.
Let me ask you this. Do you know, because I read the police report and in it, it says that she was upset. So she burned the couch because she was going to be, or she thought she was going to be sent to Houston. And she thought the staff was going to tell her mother she was going to Houston. So what is this location?
As I understand it, I may not be getting it perfectly right. There's folks that run group homes for people that have disabilities. She understands what's going on, but as you probably can read between the lines, she's not gonna get 100 on a test as an example.
Mhm.
And so this was one of those group homes where you live out in the community, but you live with other individuals and then someone monitors the group home and takes care of you. And I've represented a couple of people that do that. So that's the type of facility it is. It wasn't a lockdown facility or whatever. So she can function, but she can't function by herself if she's not with a parent or out there. Her mother called
Mhm.
us and we spoke to her and her mother will pick her up whenever she's released, because that was my other concern. And I'm going
Well,
through
let
it
me
with
ask you this.
Okay.
So with regards to Houston, is she going to be living with her mother?
She's going to start out living with mom. And then they're going to have to go through the group home application process again. And I'll just be blunt. This may sound strange, but the fact that someone has issues and set someplace in fire for these group homes is not, and doesn't mean they won't take her, because everyone in those group homes has some issues. So it won't be immediate. And her mom knows that she'll have to take her at first. And her mom called 2 days ago. I think it might have been Friday of last.
All right, so this is what we're gonna do. Is she receiving SSI?
I don't know that answer. Are you getting social security disability?
They cut it off,
Okay,
but my mom's gonna try to get me back on it, ma'am.
all right.
And thank you, Your Honor, for everything.
Oh, you're welcome. We're gonna try to get you to help, okay?
Yes,
This is what the
ma'am.
court is gonna do. Probation. This is what I'm going to do. I'm finding her guilty. I'm going to sentence her to 10 years in the prison, suspended and probated for 10 years. There's a $1,500 fine that will be probated. There's to be restitution and no contact with SRM24 Asset Company 2 LLC or 8042 Chestnut Gate in Converse, Texas 78109. If there is contact made with that location, and they say they want her back or they don't have an objection to her staying there, I'll lift the no contact order. There's to be regular reporting by Zoom or in person, regular random UAs. We can do a MIC evaluation in a DDRF in custody. If her mother has found a place for her to stay and that place is willing to accept her, then we can lift the order for DDRF. But I still want the MIC evaluation. There's to be proof of SSI within 45 days of release. There's to be no contact with minors. Field visits 1 time per month for 4 months. And would she want to be transferred to Houston?
I think no, I don't think so. Let me ask her real quick. Do you want your probation to be sent to Houston? In other words, I don't know where your mom's living. I'm sorry, I don't remember. Can you tell me?
Hopkins in
Where is that?
Cypress Springs, Texas.
Would you prefer that it be your probation be transferred there or that you
DeHunt County,
Would you prefer that?
DeHunt County, where my dad's at.
Okay, that's what you'd like and that's what you're asking the court to do.
Please, yes, sir, yes, ma'am.
All right, so this is what we'll do. Let's make some phone calls.
Understood.
And if probation, if her father wants her in Hunt County, and if everybody agrees that that's the best placement for her, we can always come back and take that matter up. Probation, is there anything else? I've given you a lot, I know. All right, is there anything else you need from the court?
I'm sorry to ask, I was just wondering when you think I'll be able to get out of jail?
Probation will be able to address that with you. First things first, I need to have that MIC evaluation done. It's a mental health evaluation at the jail. So that will give all the parties a chance to speak to your parents, to speak to this location at Chestnut to see if they would want you back and to try to find a placement for you. I cannot send you out into the world with no placement because then you won't have your medications and we'll be right back here. And if you were to violate your probation, you're potentially looking at 10 years in the prison. So I'm trying to make sure that that doesn't happen. In order to do that, there has to be safeguards, okay?
Yes, ma'am.
All right, and then there'll be GPS for half the term. And we'll do that partial for appointments. And that's for her medical appointments, probation, those type of things. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
In today's courtroom, Lindsay Phillips faced a first-degree felony for arson after setting fire to a couch inside a group home. The reason shocked everyone. She believed she was being sent away and panicked. With a history of mental health issues, the judge made it clear this was serious, but prison without treatment would only make things worse. Instead of sending her away for up to life, the court sentenced her to 10 years of probation with strict mental health care, GPS monitoring, and supervision. This was not freedom. It was her last chance to get help before prison becomes real. So what do you think? Treatment or prison? Like, share, and follow for real courtroom stories.